when we're not speaking.
No, it's ready.
Okay.
Good afternoon, everyone. Thank you so much for your patience. I'm so glad to see you all. Victoria is handing out a list of the questions that we're going to go over today. So with some room to make notes, there's pens in the back if you need a pen. We've also brought some treats. So if you want a cookie or a cupcake, they're back there, and I really do help you help yourself. And we've also got some shamrock plants to raffle off if anybody has got a green thumb and want a shamrock plant just for the St. Patrick's Day holiday. So nice to see so many of you out here today. Let me just start by introducing myself, and I'm Lori Busby. I'm one of the attorney team, part of the attorney team with Legacy Studio Estate Law. We are estate planners, and we also handle probate, generally undisputed probate matters. We'll help people through that, and we'll kind of go over what probate is and give you a background of that while you're here today. And to my right is Celia Quillian. She goes by Deanie. She's another member of the attorney team. We've got 3 attorneys in our office that focus on estate planning and probate, and we work as a team. So regardless of who you call, we'll get together and talk about matters and make sure that we're all on top of things. And we work together as often as we can. So, Deanie, you want to say a couple words to introduce yourself?
So I am Deanie Quillian, and it's nice to be back. And my background is I came from a litigation background, doing most recently fiduciary litigation involving a lot of family disputes over wills and trust. And I retired from litigation probably right when I was 50, I guess. And so I've been doing this estate planning probate practice for about 4 years now. And you can't hear me.
Oh, she just turned it on. She's
okay. Is that better? So what I was saying, I came from a litigation background involving fiduciary litigation, where families were often in conflict over wills and trust. And so the reason I love this part of the practice is it is a way to think about issues and problems to avoid those potential conflicts and to keep family harmony. And so that's a little bit of my background. I've been here 4 years, and Laurie is actually the person who introduced me to the practice. So I'm very grateful to Laurie for introducing me to Rebecca, our other partner in the firm.
Yeah, Deanie and I are actually both reformed litigators. So I used to handle insurance coverage disputes before I became an estate planning attorney. So we knew each other a long time ago, and thankfully we got to reunite together here in our practice. So to kind of keep this a little interactive, we'll welcome you to ask questions as we go through the different questions. If you want to wait until the end, if you have some more specific questions that we haven't dealt with, please feel free to raise your hands. If you can hear us, definitely let us know and we will speak up, but we'll get started. We're just going to go over the questions in the questionnaire. So let's get started.
Okay. So Laurie, who would you say needs a will?
My easiest answer is everybody. I can expand on that by saying everybody that really cares about who gets their assets after they're gone. If you don't have a will, the state gets to make that decision. But if you have assets that are in your name, you have family members that you are interested in getting a larger share of your estate. I mean, really, anytime you want to ensure that your assets are directed to specific people, because Deanie's going to go into a little bit further about what happens when you don't have a will. But
and Laurie, let me ask you, statistically, how many people in Georgia, when they die, have a will versus those who do not?
This is the sad part. I would say probably about 70% of people in the state of Georgia. Probably 70% of the people in the country don't have a will. So, I mean, yeah, it is a pretty shocking number. And, you know, I hesitated a second ago because I like to say that, you know, our firm motto is really bringing peace of mind to our clients. And I think it provides the greatest peace of mind when you can you've worked a long time in your lives. You've created your own wealth, you have your own assets, you have a legacy, and you have family members and friends that maybe you want to share that legacy with. And if you don't have a will in place, that makes it a lot harder for that to happen. So kind of.
Okay, well, she's going to answer that question. So.
Go ahead. Did you want to ask a question? Great question. Excellent. Okay, absolutely. And there's probably a lot of people in this room that maybe are not native to Georgia or have moved here recently. If you have a will from another state, I do suggest that you get in touch with a Georgia estate planner and have them take a look at your will. And they can look at it and see whether it has all the same qualifications that Georgia requires. And if it does, then you may not need a new will. But if it's missing some things while you're alive and you have capacity to do so, making those changes now makes sense. So don't kind of rest on the idea that, well, I created a will and it might be from another state, but I have a will, or I've written something out or printed something from my computer that I've signed, and that is my will. I would encourage all of you to consider contacting, if it's not us, contact an estate planner you're already dealing with, a family member that's an estate planner, but definitely show someone your document ahead of time to make sure that it meets all the requirements that Georgia has for a valid will. There aren't many, but it's important that you meet those requirements. There's witnessing requirements, notarization requirements, affidavit requirements on there that you definitely need to make sure that your will is in compliance with before you pass away.
And one of the reasons you want to do that, as Laurie referred to, is Georgia has what's called an affidavit of due execution. And if you have that affidavit of due execution that is executed at the time that you're executing your will, it makes it much easier on your loved one, family member who is charged to be the executor of your estate to be able to probate your will. So in Georgia, it sets forth certain requirements that have to be in that affidavit. And often we see wills from other states that don't meet those requirements. So when it comes to probating an out-of-state will, we are required to find those witnesses and have them sign interrogatories to witness before we can start the probate process.
And I wanted to add one other point to the issue of who needs a will. If you have family members, grandchildren, nieces or nephews that are minors, and you want to leave assets to them, your will is the best way to do it. You don't want to leave assets directly to minor children because it creates all other, a myriad of issues that will require the court to get involved and appoint a conservator, which is a complicated and complicated process. It adds expense. So if you do have grandchildren that you specifically want to take care of, or nieces and nephews that you want to leave money to, having a will in place that, you know, has the necessary terms in it to make sure that that money doesn't go outright to a minor child is a great way to do it.
What about a POD for a minor child?
So a POD works unless what you're leaving is more than $25,000 in assets, because if it's more than $25,000 in assets, Georgia requires a conservator to be appointed, and you have to go through that process. And we're going to talk a little bit more about PODs. If you have a will, you can direct that the child's legal guardian or parent is the one that you want to be in charge of those funds through what's called the Georgia Minors Transfer Act. And then it will stay under their care and direction until the child is 21.
I didn't have a good alternate executor, so I had to have a fiduciary attorney to be in case, everybody else is gone, that he would take care of it. I just wonder, what do you have to do to make it easy for the fiduciary attorney to do his job then?
So, and we're going to talk a little bit more about that in the probate process, but generally when you're naming a third-party fiduciary, you just want to make sure that they have the information. And was this the drafting attorney who is acting as your fiduciary executor?
No, it's somebody that
He specializes in this.
somebody, that's nearby that he
Recommended.
that he knew in Decatur. So
Okay, so that's great. So that is not unusual to name a third party as a fiduciary if you don't have, friends or family members that you want to put in that position. But you just want to make sure that he knows where your original will is located so that if something happens to you, he will be able to start that probate process. And generally, we recommend leaving information for whoever your executor is regarding sort of an outline of where your assets are located so that when the time comes that they know where those assets are, as well as those individuals who have advised you during your lifetime, such as your CPA who prepares your taxes, your financial advisor, to give them those that contact information for those people as well.
Dee, what happens if you die without a will?
So if you die without a will and you have individual assets in your name that do not have beneficiary designations, then you'll be required to have a probate called a probate for letters of administration. And that is where somebody who will petition the court to administer your estate in accordance with Georgia law. And Georgia law will dictate how your assets are to be distributed among the legal heirs that Georgia, through statutory provisions, mandates how it's to be divided. So, for example, if you die without a will and you have a spouse and you have 2 children, then your spouse is entitled to at least 1/3 of your estate, and your 2 children would then also get 1/3 each. If you have more children, it would be divided equally among your children. And so your children's 2/3 share is divided by however many children you have. It gets more complicated if you don't have a spouse, if you don't have children, because then it first goes downward. So it goes to your spouse and children. Then if your children have predeceased you, it then goes to the next generation, to the lineal descendants. If they didn't have any lineal descendants, then it goes up sort of like a fountain up to your parents. Assuming your parents have predeceased you, then it goes outward and down next to your siblings. So your siblings would share, but if your siblings, one of your siblings has predeceased you, their share then goes to their lineal descendants. So you can see that it could get very complicated depending on your family structure. And, Georgia's, dictating how much each of those heirs, according to the law, will receive. And it could be that, there's a distant great nephew that you might not want to receive the same share as your sibling. So that's what happens through the probate process. If you die without a will, Georgia law is going to dictate how your assets are distributed. Span.
If I have a bank account, do I have to put that in the bill, the big money account, or
So she's asking if she has a payment on death or a transfer on death on a bank account or savings account. Do you have to indicate that in your will? You do not. You do not have to put that in the will. That can just transfer outside of probate directly to the beneficiary. And we'll talk a little bit more about that. Laurie, why don't we give them an overview, just generally, if you have a will that you're probating, what the steps are through that probate process.
Sure. So just generally speaking, so probate itself is the court process of administering your estate. It is what gets the executor formally appointed and gets you either letters testamentary or letters of administration that are we call them the authorizing documents. That's what the executor or administrator, if there is no will, takes to banks and credit card companies and life insurance companies to say, I've been appointed by the court. I was nominated in the will if there was one. I've been appointed by the court to serve, and I have the authority to look into what accounts there were, how much were in the accounts, who the beneficiaries of those accounts were, right? So the probate itself, some of you may have already had some experience with probate. Some of you may have had some experience with probate in other states. Georgia is one of the states that it's fairly simple here. The court doesn't really get involved all that much in the process beyond filing the initial petition. And I'll go through the steps here, and Deanie can talk about what the different kinds of petitions are. But so you file the petition with the court and you say, I either want to be appointed as the administrator or I've been named as the executor in a will. And the court gives you an oath. There may be a publication that's involved depending on whether you're applying as the administrator or the executor. The court will do the publication or you'll have to do it. And basically that's to give people the opportunity to object to you serving as the administrator of that estate. But essentially, once that happens and you've been appointed as the administrator, most people, especially if there is a will, and this is one of the nice things you can do if you have a will, if you feel comfortable with who the people are that you're appointing as an executor, you can waive certain requirements that the state puts in place with regard. Sometimes an executor would have to file an inventory of all the things that there are in the estate with the court. So they would have to go through and list what all the assets are and how much they're worth. They may also have to post a bond depending on how they're, if the will doesn't say it's waived or if they're appointed as the administrator, there may be a bond required. But if you execute a will in advance and you appoint the people that are going to serve as your executors, you can say in your will, basically, I trust these people. That's why I've chosen them. So I'm going to waive those requirements for inventory, for bond, for any other reporting that the court may require. So that's another benefit to having a will in place, because those things all come at an expense, both in time and money for your administrator. They, they may have to go to an attorney to help them fill those things out. That's going to take money out of your estate and money away from your beneficiaries. And it takes time to file those things. There's deadlines associated with them. And so, to the extent that you can avoid those things for your executor, that's a very nice thing to do.
Yeah, I'll just interject one thing on that front. It's also a privacy issue because those things will be a public record. It is not saying that the person that you're putting in that position as fiduciary executor of your estate is not responsible for accounting to your beneficiaries. They always have to do that. They have that responsibility. It just allows you not to have all of that information on the public records if you waive those requirements in your will.
Yeah, excellent point. So following along with what is probate and how does it work, generally the probate happens in the county in which you were living at the time of your death. So if most of you probably are DeKalb County residents, it would happen in the DeKalb County Probate Court. Your executor would go to the court, file a petition, and if they're named, or if you didn't have a will, your administrator would go to the court and petition the court. So let's just take it from the standpoint of you have a will, because this is a room full of very smart people, and I think you're probably all headed down the road, if you don't already have one, to probably getting a will. I have imagined that's why you're here today. So let's take the example of Joe passes away. He has a will, and he's nominated his daughter as his executor. So what his daughter will have to do is, she may have some siblings, and in Georgia, when you file a petition for probate, and what the court has to do is they have to verify that the legal heirs are in agreement with the will. So when a petition for probate is completed, it has to be given to the legal heirs, which are different than the beneficiaries under the will. So you may have, let's say you have 3 children, one of which is really wealthy on their own, so you don't feel like they need your money. But your other 2 kids, you want to be sure you take care of. All 3 of your children are legal heirs. The 2 that you name in your will are your beneficiaries. So what has to happen with the petition for probate is the legal heirs have to review the petition, have to look at the will, basically acknowledging that they've seen the provisions of the will, and they've seen who's been appointed as executor, and they are consenting to that person serving as the executor under the will as it's written. So the first thing your executor has to do is they've got to get a petition completed, be it on their own if they kind of feel like they're comfortable with the process, or by going through an attorney and having the attorney complete the petition. And then they have to go to the legal heirs of the estate and have those legal heirs sign off on that petition. So.
This doesn't apply if something is payable on death, correct?
Correct. This does not, this only applies to assets that come through the probate estate. So, and just to kind of jump ahead, let's talk about the difference between those two. If an asset has a beneficiary designation, like a 401k, an IRA, it has a payable on death designation, like a bank account, or a transfer on death designation, like an investment or a brokerage account, or it's jointly owned property, where it's joint with right of survivorship, keywords with right of survivorship, then those assets are going to go directly to the people that are named as beneficiaries. They're not going to come through the probate estate. They're not going to be in the purview of the executor to handle. The only thing that the executor may get involved in is trying to figure out who those named beneficiaries are if nobody knows. So they take their letters testamentary and they submit it to the company, and they ask the company, please advise us who the beneficiaries are on this account, so that I can make sure they contact you, give you a death certificate, it can make the claim. But otherwise, they're not, those assets typically are not in their purview. So you're absolutely right. So those assets that have those designations, or that are jointly owned with others, are not going to be part of the probate. So we're concerned with, we're filing the petition that's consented to by the legal heirs. And then let's say you can't find somebody, the court can publish a notice that we've got to know something about who those legal heirs might be. So if let's say somebody died without any children and they have siblings, but the executor doesn't know who those siblings are or where they are, it's very helpful for you to leave behind the last known address for that person, some information that would help your executor be able to locate them. Because if they can't directly get a signature, there's going to have to be notice that's filed.
And that just delays the process of probate.
Absolutely. Delays it, makes it a little bit more expensive, absolutely, time consuming. But let's presume, again, we've got Joe, his daughter is his executor. She can get her siblings to sign off on the petition, and she's taken the petition to the court. Used to be, you could take your petition to the court and on the same day, take your oath and get your letters testamentary. We loved it when it was that way. But it's no longer that simple. The courts, every county has got its own little system going on right now. And it's really changed since COVID, as you can imagine. The court shut down, they got fairly overwhelmed with cases, and they changed the way they were handling things. DeKalb, for example, right now, well, they had the additional impact of a flood with burst pipes in the courthouse that closed the courthouse for a long time. But DeKalb, basically you can go, I think, without an appointment now.
You can right now, they just reopened. They probably will start getting really busy and then we'll reinstitute appointments.
Right. So if you needed an appointment, you would go online and book an appointment. And sometimes they're weeks out. You can't get them instantly. But DeKalb is one of the nicer places that we've experienced because they also allow walk-ins when they're not busy. So, let Joe's daughter goes to the court, she walks in. Now what happens is they may give her oath, but they're going to tell her that we can't get an order issued or your letters issued for a little while. Maybe it's going to be a week. We'll mail them to you. So she goes home, she waits, she gets in the mail a package from the courthouse that has a bunch of certified copies of letters testamentary. And now she's got the document that she can go to her dad's life insurance company, to his investment companies, and ask for information about those assets. So because her first job is to marshal all the assets of the estate together. And what she's going to do with those is, for the most part, maybe not with some IRAs and other things that maybe don't have beneficiary designations on them, but she's going to open an estate bank account. She's going to get a tax ID number for the estate. She's going to open an estate bank account. We really love to suggest for our clients that they immediately initiate a relationship with a CPA. Have that CPA get you the tax ID number. Because there's going to be advice that you're going to need from a CPA over time. So you open the estate bank account by getting the tax ID number, going to your local bank, and do that. And then the other really key thing that has to happen at the beginning of this process is that you've got to file what's called a notice to creditors. You have 60 days from the day when you're appointed as the administrator or executor to file a notice to creditors. And basically it gets published in the county paper, which I think is the Champion here in DeKalb. Yeah, in DeKalb. It gets published in the Champion once a week for 4 weeks. And then that's to notify creditors that this person has passed away, that an executor has been appointed. And then creditors have 90 days from that last publication date to submit their claims to the estate. The executors have really 6 months from the time they get their letters to really get their arms around what's in an estate before they have to start paying debts and do anything. So, ideally you get your letters, you publish your notice, you get your bank account, and then you start your job as a detective, investigating what the estate had, looking through the mail, checking to see what documents you've got, bank statements and retirement account statements and things like that, see what has beneficiaries on it and such. You transfer as many of those assets into the estate account as you can. And then you're waiting out that creditor claim period. Maybe there's some small debts that it makes sense to try to negotiate with those creditors over that time period. And then you are, if there's real estate in the estate, if there's a house that needs to be sold, you're contacting a realtor, you're going through the process of getting that listed, and you're doing all this as the executor of the estate. There's a car, you're selling that car and signing the title over to the buyer as the executor for the estate. You're signing the listing agreement for the real estate as the executor of the estate, doing all that. So, and then once I want you to continue that relationship with the CPA. So Joe's daughter is going to go back to the CPA and say, okay, my dad died in 2023 and he earned some income for that time period. Maybe he was just getting his required minimum distribution from his IRA account, or maybe he was still working, but he may have an income tax return to file. So the executor would be responsible for making sure the last income tax return is filed. Also, if an estate makes more than $600 a year in income, meaning if you have an investment that makes that much money, or a capital gain, or things along those lines, then you may have to file an estate tax return. So there's reasons to stay in touch, have that relationship with the CPA when you're the executor, and to facilitate that. So
I'll mention one other thing.
Yeah.
Laurie mentioned, so like if somebody dies in 2023, they'll obviously have a 2023 income tax return due. So the executor is responsible for filing that individual income tax return. But the executor is also responsible for filing all past due tax returns. So you're really doing your executors a favor by making sure that you complete those tax returns and file them each and every year. Otherwise, your executor is going to have that burden to bring all of those tax filings current, along with the payments and penalties and interest that are due.
Does the executor have to be a resident of Georgia?
no, ma'am. No, they do not. There are some states that require the executors to be residents, but Georgia does not. So, oh, sorry. Does Georgia require an executor to be a resident of the state, the state, in order to serve? And Georgia does not.
I always thought they advertise because of if the deceased had debts, but I have people tell me that they do not have to pay the debt.
Well, it really, okay, so she brought up the issue of, that she understands that people have to advertise, but there may be instances where debts of the estate do not have to be paid. And that is true. There are priority expenses of the estate. There are ways around debts having to be paid by the estate. It's probably a little more sophisticated estate planning or probate work than the ordinary estate, but I'll give you one example. So if a spouse is the only beneficiary of an estate, or even if they're not, but generally where there's a spouse, when it comes time to probate the deceased spouse estate, and that, let's say they had a significant amount of debt from a last illness, or they ran up a bunch of credit card debt that was in their name only before they passed away, then there is a mechanism by which that spouse can file what's called a petition for year support, which basically is asking the court to let me have the assets of the estate, and you're without the requirement for me to satisfy those debts, because I, as the spouse, need this money in order for my, for my year support, for me to continue living. So, I don't know if you want to add anything more on the petition for year support.
No, a petition for year support is a very useful tool to use in instances where there is a lot of unsecured debt, often when you have a surviving spouse or you have surviving minor children. I was just going to add, often you can negotiate with unsecured creditors because they would rather have their money in advance, but you always have to be careful about that, because there is a requirement that all unsecured creditors of the same priority be paid on the same pro rata basis. The other concern is if you don't pay the creditors of the estate, then you're not going to be able to be discharged of all liability and acting as executor of that estate. Even if the heirs sign off, if there is a creditor that you received notice that they had a claim, if they filed something with the court, the court's not going to discharge you until that claim has been satisfied. And even if they didn't file something with the court, if you had notice of it, I think there's a good likelihood that there could be a claim that they wanted to pursue it against the executor.
Right, because one of the last things, once you've handled the taxes, paid off the debts of the estate, and made distributions to the beneficiaries, even if it's yourself as the sole beneficiary, you've taken the money from the estate. We're always going to recommend that you file what's called a petition for discharge. And that is asking the court to relieve you of your liability as the executor, because you're a fiduciary of those funds. You're a fiduciary for the benefit of the creditors as well. You have to make sure, like Deanie said, there are requirements that certain debts be paid. And certain debts have priorities. The expenses of the estate, funeral, expenses of your last illness will have priority over other unsecured debt. So, and you are going to have to, in your petition for discharge, you're going to literally have to write the words, all of the debts of the estate have been paid. And then what happens is the court files a publication once that petition for discharge is received, and they publish that this executor is asking to be discharged. If there's a creditor out there that you haven't paid, they may submit a claim to the court saying we're a creditor of this estate and we were not paid. And in the absence of you representing, in the absence of you paying that bill, that creditor may have a valid claim that may stand in the way of you getting discharged as the executor. Go ahead, sir. You had a question?
With newspaper circulation, haven't creditors find out what's
It's the publications, paper publications have declined, everything's online.
Yeah.
So every legal newspaper has an online site where creditors can search for these death notices. It's called a notice to debtors and creditors.
Do they hire companies that
They do. Debt collection companies are always searching for those notices.
And petition of discharge, if you don't do that.
So go ahead, Dee.
So you don't have to file a petition for discharge, but if you don't do that, it just exposes you to potential liability in the future if the court has not granted you that order saying you have completed your responsibilities and execution of your responsibilities as an executor or administrator of the estate. So, oftentimes people make the choice not to do it. We just always advise that you're better off spending that little bit of money and filing that petition for discharge. It's less than a couple of $100s to file that petition. And so for that peace of mind, I think it's well worth knowing that you're never going to have anybody filing a claim against you.
And that petition for discharge, it will take a little bit of time. So like I mentioned, there is a publication that is submitted by the court with that. It usually takes the court anywhere between 3 to 5 months on average right now to grant a petition for discharge to relieve you of your duties.
How long does one have to file for probate? Is there a
You
statute on probate?
actually, no, you can file at any time, but obviously it's going to be a lot easier if you can file as soon as possible, because the record keeping and contacting people is going to be much easier, but there's no statute of limitations on that. I couldn't hear the question. So if you have a will, there's actually a statute that says even if you don't probate that will, the original will is supposed to be filed with the court where the decedent died at the time of their death.
But is there a time frame? Do they have like a year
I was just looking at, oddly enough, I was just looking at the statute this morning. And I think it's just a prompt requirement. There's not a specific time period, but it has to be filed promptly. And I think that is going to be open to the court's discretion as far as what promptly is. But if you do have it and you don't file it, and let's say, for example, somebody else is trying to become the executor and they only have a copy, but a sibling of the deceased has the original will and they're not willing to file it, it can be a sanctionable offense from the court.
If it's notarized and you have limited income, is all that still apply?
Georgia does not have a small estate statute. So if there is going to be a probate, doesn't mean that the will has to be probated. It
Right.
just means that the original will has to be filed. If the debts of the estate make it so that it doesn't make sense to file a probate, let's say that there's a lot more debt than there are assets in the estate, then the executor doesn't have to open an estate. You don't have to do that. Or if all of the assets of the estate pass via beneficiary designation, then there may not be a reason to open an estate and then subject, all of a sudden subject the executor to having to be contacted by creditors. So let's just kind of touch on that, Deanie, actually. So, one of the main reasons that estates have to be open is if there's real estate, because that is something that you can't put a beneficiary on here in Georgia. So if you don't own real estate, if you live in a rental apartment, per se, what ways can you set up your estate so that you don't have to go through probate?
Yeah, so if you want to avoid probate, if you have no interest in real estate, then in Georgia, you can use beneficiary designations and you can use joint ownership. So you can have somebody as a joint owner on account. Beneficiary designations make a lot of sense in that asset passes out of probate and the beneficiary is still getting what we call a full step up in basis of the asset upon your death when it transfers. I don't know how many of you are familiar with that term of a step up in basis. But my example is if you purchase Coca-Cola stock and you purchased it for $10, and at the time of your death, you still own that Coca-Cola stock in an account, and you put a beneficiary designation on it to whomever you want, and the stock is now worth $100 at the time of your death. Your beneficiary gets the benefit of not having to pay any capital gains tax on that $90 increase that has occurred during your lifetime. They get a full step up in basis so that now their basis in that stock is $100. So they may choose to hold on to the stock and just let it grow. And then whenever they go to sell it, it will be taxed at the level of whatever the difference of its value at that time, minus $100, because that's their basis. Or they can choose to sell it and not have any capital gains tax, even though it increased significantly during your lifetime. So beneficiary designations make a lot of sense. The other way you can transfer assets to avoid probate, like Lori said, is to set up joint accounts so that you have a joint account owner, so that upon your death, the asset passes directly to the joint account owner. That type of situation is more problematic for a couple of reasons. When you name somebody as a joint account owner, first of all, you're giving up some control of that asset because they have full access to use that asset as well as a joint account holder. The second issue with that is that you are essentially gifting half of that account to them. So depending on the value of that account, you may actually need to file a gift tax return if you have $100,000 account and now you're gifting them half the value of that account. And so you would always want to check with your CPA if you're contemplating naming somebody on a joint account, such as a savings account, to make sure that you wouldn't need to file what's called a gift tax return in the calendar year where you have made that change of ownership. And so those are some concerns. So it's the loss of control potentially of that asset because the joint account holder can just go and take all of the assets if they want. The second thing, the loss of that benefit of the full step up in basis of the assets in that account. That's not as much of an issue for a checking account or a savings account where you just have cash sitting, right? But it is a concern for investment accounts. And then the third issue, I've just lost
The
my
gift
track.
tax
The
return.
gift tax return. So just considerations to think about. So Lori, if you have real estate, what do you recommend if you're trying to avoid probate?
Sure. Let me just go back to the gift tax return question for a minute, or point for a minute. When you file a gift tax return, many of you may have already done this, so this may be something you already know, but that doesn't mean there's going to be any tax due. We all, right now, today, sitting here in this room, can give away almost $13 million of assets to anyone we want without our estate having to pay any estate tax or inheritance tax, if you will, on that. And what happens when you file a gift tax return is it counts towards, it's the IRS's way of tracking what counts towards your 13 million. So if you give your son $100,000 this year, it's going to count, you're now going to have 12,900,000 that you can give away later on without having an estate tax. So it's not necessarily there's going to be a tax obligation, but you've got to go to your CPA and file a gift tax return. Somebody's got to keep track of it. Because if nobody knows about it when you pass away, it's going to be a lot harder for them when they're trying to calculate your assets.
To the point now where you can give up to 17,000 without making any paperwork at all.
You took the words right out of my mouth. That's it. Right now, that we can give anybody $17,000 without having to file a gift tax return. So, and if you want to give, let's say you want to give $30,000 to your children, and you say, well, I don't want to trigger a gift, your husband, your son and his wife, I don't want to trigger a gift tax return. Give $15,000 to your son and $15,000 to his wife, and you can take care of it without triggering the gift tax return issue.
And they don't have to report it either.
They don't either, correct. Yes, ma'am.
State tax.
Well, it's going to be about a 40% at a 40% rate for the estate. Well, if it's everything that's over 13 million. So on the first dollar over 13 million, then it's basically 40 cents of every dollar essentially.
Most people don't have to worry about that.
That's correct.
Right.
There is going to be a sunset of that tax exemption that you've probably heard about. So in 2026, unless there's a legislative change, it goes down to around 6 to 6.5 million adjusted for inflation. So people are keeping an eye on that.
So going back to your question, if you have real estate and you want to avoid probate, what are some options you may have? And I want to touch on the joint ownership first. So let's say you have a house and that's really your only asset. You've got a couple of other accounts, maybe a retirement account, and you've got one child and you decide, I'm just going to give everything to my child on my death. So I'm going to go ahead and put my child as a beneficiary on my accounts. And then what can I do about my house so they don't have to go through probate? I'm not sure I understand. Siri doesn't understand, but I'll explain. So what you could do is you could put that child as a joint owner with you on that house. But I really strongly second Deanie's reservations with regard to doing that. Because most importantly, in this market that we have, if you have a house that you bought 20 years ago for $150,000 that is now worth $600,000 or $700,000, they're going to lose that step up in basis and be subject to a significant capital gains tax issue. So that alone is a really, it to me is one of the biggest factors in telling you why not to name your child as a joint owner on your property with you. If there hasn't been a whole lot of gain, and that's not really going to be an issue, And then maybe it's something you want to consider. So making that person as a joint owner on that real estate may be something to consider. But there are other mechanisms.
Yeah, always a great conversation though to have with your tax
Yeah.
advisor, your CPA.
Absolutely. So another option is, I'm sure a lot of you have heard of people that have trusts, revocable trusts. I'll tell you here in Georgia, and just to kind of condense this, because I know we're kind of running out of time, but, oh, thank you. There's not a whole lot of reasons to have a revocable trust in Georgia because probate is so simple here and so inexpensive. But one of the reasons is if you want to pass your property without it going through probate because of privacy, or if you have out of state property, let's say you had a vacation home in Florida. Florida's probate rules are onerous and probate in Florida is very expensive. So what we recommend to anybody that comes to us with and is setting up an estate plan and has a second home in another state, is that they, depending on how difficult the probate would be in that state, and typically we find there's not many states that are as easy as Georgia, but we would recommend to them that they retitle that house. We would set up a trust for them, a revocable trust that is in place during their lifetime. It's controlled under their own social security number. They have full control of that asset, just as they would before they had a trust. But they title that property to the trust, and then it passes pursuant to the terms of the trust without probate. Yes, ma'am.
How hard is it in North Carolina? I have a place in North Carolina. How hard would that be? I mean, you know.
Yes, well, we've had a couple of clients with homes in North Carolina where we have set up trusts just because it's just an extra layer of time and expense, regardless of where it is. And we've worked with North Carolina Council to help us put those deeds, but it's sort of a judgment call of whether or not you want to put the time and planning now to set this up to make it easier for your executor so that they don't have to go through an ancillary probate proceeding in another state. Because what happens when you have to do that ancillary probate, you have to have the Georgia courts certify the probate here, and then you have to go and start a new probate process in the other state. So, anyway, it's a cost savings.
And sometimes it's not only the cost. Like, for example, I had a client that had South Carolina real estate and another client that had Vermont real estate. It has taken 2 years to handle the probate and transfer the property in Vermont, and it took a year for it to happen in South Carolina. And it was a very simple estate. Beneficiary designations for the most part, one house here in Georgia and one property in the decedent's name in South Carolina. The estate could have been open and closed in 6 months, but it took them more than a year because they had to go through this extra process. So it is, yeah, it's not always just the expense, but it's time. And to be honest with you, sometimes serving as an executor can be a full-time job for somebody. And one of the things that we have on the table over there, just to point this out, is we've got a little green flyer that kind of gives you some tips on who you should think about, some things that you should think about when you're figuring out who your executor is going to be, what their job involves, and then also considerations for who might be a good fit for that job. So I digressed for a minute, but let's go back to the revocable trust piece. Yes, ma'am.
And this would be a reverse question. I've got a house here, house in North Carolina. I've got 2 children, and I'd like both properties to be sold in its split. So it sounds like they should be put in the both or not.
You know, it really depends. Your house here, and if you're thinking about doing a revocable trust because you have out-of-state property, then yes, I would tend to agree with you. You might as well go all the way and transfer your property here in Georgia. But there's different factors that go with that. There's an expense related to all of that deed work that you need to do. And there's work to do when you set up a revocable trust. I mean, it's not as, we have lots of clients. I had one that emailed me this morning. I set up a trust for them last year. They wrote me this morning and said, okay, what do we do to get our things in the trust? It's just, we send out a funding memo to our clients when we set up trusts with them that explain all of the steps that you have to go through. It's work. You've got to go to your banks and retitle accounts or put your trust as your beneficiary on those accounts. You've got to get deeds redone. You've got to remember, anytime I buy anything that has a title to it, I need to title it to my trust. You've got to make sure your home insurance your trust is at least an insured on your insurance policy. There's work that comes with it. So we don't take lightly the idea of just recommending to all of our clients, oh yeah, you should be in a trust. I think it is really important for us to sit down and talk through all of the circumstances to figure out whether a trust is the right fit. You know, our wonderful partner, Rebecca, gave me a statement a long time ago that travels with me all the time. I don't want to put somebody in a Cadillac estate plan that really only needs a Camry. It is our goal to make sure that your estate plans are as simple as possible for what you want to accomplish. We don't want to create more complexity for you, which drives your concern and nerves about what your family members may have to do for you. We want you to have that peace of mind, and we want everything to be as simple as possible. So, well, I mean, let's talk about this idea of a revocable trustee. Do you, I mentioned some things, but I know that there's other considerations that we want to share.
So there are definitely some of the other considerations of why you would want to have a revocable trust. We often use them in blended families just to avoid potential disputes and probating a will. We will use them in situations where a child is going to be treated differently than their siblings so that there's not a potential for a contest of the will. We also use them in situations where there is an heir of the estate who is either a minor or who is incapacitated, that if we use a regular will, probate's going to require appointment of a guardian ad litem to represent their interest, which can increase the cost of the probate and delay the proceedings of being able to distribute assets to the beneficiaries. So those are some other considerations of when we're talking to our clients about their specific circumstances, that we're thinking about what is going to be the best solution to meet the client's goals and how they want to set up their legacy, who their beneficiaries are, and then at the time of their passing, what is going to make it easiest for the persons that they've designated as executor or trustee to be able to carry out their wishes.
I'm going to add 2 more points to that. One is another reason to have a revocable trust is incapacity planning. I've got one particular client that I'm thinking of in my mind who is in his 90s, sharp as a tack, but we've set it up so that his son, he has a trust and his son is the co-trustee with him. And this way things can operate seamlessly if he does lose capacity, or even upon his death, the son already is in place as the trustee on his accounts and can just continue on doing what they were doing with his accounts. He has another son who's disabled, and they provide for him. And it allows that the person that you name as your trustee, or in this instance, co-trustee, to basically seamlessly continue administering your assets just as you did during your own lifetime. So it's a good mechanism for planning for incapacity. And then I want to kind of go back to something Deanie said with regard to, like, if you're going to treat your children differently in your will. I'll give you a different example. Let's say you don't have any children, but you have a couple of siblings, and one of your siblings you're not close with, but the other one you are, and you want to really leave all of your estate to that sibling that you have a close relationship with. But your other sister, she's a troublemaker, and you know that she's going to get involved in this process. So remember when I talked about when you when you first put together a petition for probate, you've got to get consent of the legal heirs. Well, both of those siblings, the one that's going to inherit and the one that's a troublemaker, are going to have to sign off on that petition. So a way to avoid that is by setting up a trust so that your trustee basically takes over the assets, because your beneficiary designations are going to reflect that things come into your trust, or they're going to be able to take control of your house and do it all without probate and give the money to the sister that you wanted to inherit without having to get the problematic sister involved. So, it's the same thing if you're going to treat your children differently and you have a child that you don't have a good relationship with or is not good with money. There are ways that you can handle your assets to take care of that. Did you have a question?
Revocable, is there irrevocable trust?
There is. That's an absolutely great question. You want to take that one too?
Yes, there are irrevocable trusts. You might be most familiar. It was a estate planning tool that was used a lot in the 90s and the early 2000s before we had these very large lifetime exemptions. Life insurance was often put in irrevocable life insurance trust. They're referred to as ILITs. People of significant wealth who have a taxable estate will still use irrevocable trust as well. It's more unusual to see that now, just because of the exemptions that we've had as far as what a taxable estate is. And it's more limiting in that you are giving up control of those assets once you place them in an irrevocable trust.
So revocable trust can be renewed.
Yes, a revocable trust. And sometimes you'll also hear it referred to as a living trust, because while you're alive, you are the beneficiary of that trust. You are also usually the trustee of that trust. So you're using those assets for your exclusive benefit during your lifetime. So the revocable / living trust can be amended at any time, modified. It can be revoked if you decide later down the road that you don't want it, that your circumstances have changed. You can simply revoke the trust as well.
My question, okay, you have a trust for your family house in the mountains.
Mm-hmm.
And your children, that you die, and then you have somebody in that family who is managing the trust, but the property is still owned by the trust. And then can the siblings who own it through the trust renew that trust?
So I think it depends on the trust provisions for that. And I'm not sure if that may be a specific situation where there is an irrevocable land trust that's been set up that has dictated that it's going to be managed for the benefit of that family for whatever the terms of the trust are. But generally, when we're putting land into a trust, it's to avoid probate, and you can change that at any time.
It's after the original grantor of the trust. If you were the person that set up the trust, after your death, generally the trust becomes irrevocable. There are mechanisms under the law to make amendments to it, but usually they're in very limited fashion and they can be expensive to be made and require a whole lot of consent from different individuals. So it's revocable during your lifetime. You can amend it, revoke it, do whatever you want with it. But upon your death, that's when it becomes irrevocable generally. Okay, we've got two questions. So let's go all the way in the back first.
You have to go to a nursing home. Does the trust protect your assets or benefits? What happens to your the money that's in, let's say, it's not after you have beneficiaries and you need to go to a nursing home?
Right. Yeah, asset protection for that purpose. So we actually don't do that type of planning, but we do have somebody who's very good. His name is Dan Munster, who is a planner who does estate planning for Medicaid long-term planning. He might be a great person, Victoria, to invite at some point to be a guest speaker here. Okay, but that's very specific planning.
Like if you have your money in a trust fund for your children, or you have your money with the stock account for children beneficiaries, it's not protected against the nursing home.
Yeah, I'm not sure that it would if you have any control or access to those funds. But there again, we don't do that specific type of planning. There are two areas of planning that type of Medicaid, Medicare planning, as well as special needs planning. We have advisors. So if you have a disabled child and you're concerned about providing for that disabled child and making sure that whatever assets you want to leave to them do not interfere with the type of government benefits that they either qualify now for or could qualify for in the future. We also have people that we can refer you to for special needs trust planning.
Go ahead, sorry.
I had two questions. One is, if you have surviving spouse, do you have to determine?
So if you have a surviving spouse, it may be that most of your assets are jointly titled, so no probate will be required. So usually spouses own property as joint tenants with right of survivorship, so that upon the first spouse's death, the second spouse merely files what's called an affidavit of title with the court that transfers that ownership 100% to the surviving spouse. Likewise, any joint accounts that you have or retirement accounts that have a beneficiary designation to your spouse, all of those assets pass outside of probate. So it is very likely that when the first spouse dies, that probate would not be needed. We're always concerned about that car accident where something would happen to both spouses. And so we never like to rely just on the fact that everything's going to pass to the spouse in that type of circumstance. We want to have a backup plan. We want to have a will in place, even if it's a simple will.
The other question is, how do you prove basis?
So how you prove basis is through your records, through either your CPA or with the investment company that holds that asset. They should be able to provide you with the cost basis for each individual stock that you have purchased in your account.
What if you haven't purchased it with that particular institution? So you go back.
Like you had transferred it from another institution. There's probably still a way for your financial advisor based on the time period of when you purchased it to be able to establish some type of basis for you.
And with real estate, it's doing an appraisal. Basically, appraisers can do that.
How is compensation for your trustees or executors that aren't a law firm determined?
You want me to?
Sure.
So for compensation, Georgia has a statutory provision that if your executor or trustee elects to take compensation, then it's a statutory fee. And for executors, it's essentially 2.5% of the probate assets only that come into the estate, and then 2.5% of the assets that are paid out of the estate. So, and again, if there are assets that are passing outside of probate, that is not included in that fee. And often family members, especially who are acting as executor, don't charge a fee only because it is taxable income to them. And so it could change their tax bracket, have other consequences, or they just want to do it out of, appreciation and love for the person who's died.
Yeah, a lot of family members don't end up taking a fee. And in the trust, it's this, there's a different scale under the law with regard to how trust assets are valued and what compensation they can take. But you can always have a written agreement with your executor, a contract that says, if you're serving as my executor, you're going to take a fee of X dollars if you wanted to.
Yeah, and you can actually put that provision in your will as well. You can set a specified amount that they are to receive in lieu of that statutory fee.
Right. Anyone else?
We'll remind them about the sign in the back and the shamrocks for good luck. Think we may have a few Irish folks in the building. Maybe
Okay.
Molly Husby, I don't know. but-
Irish folks with the green thumb, if you have any interest, we've got 4 shamrock plants back there that we've got, you can definitely drop your name in the cup, or if we've only got 4 takers, we'll give away the 4. We've also got our business cards back there. We've got treats, and we've got the green flyers with some information about executive recommendations. And we'll hang around for a few minutes if anybody has any specific questions they want to check in.
Deanie and Lori, really, what a gift that is.
Thank you so much for having us.
Thank you.
This is from Zoom. Thank you, but also.
Yes, it is.
North Druid and.
May
Beacon
I
Highway,
speak
right
from
off of
Zoom?
85 on North Druid Hills.
What's the name of the form that
That's fine.
everybody has to sign
So my
saying that the
husband
will
said-
is about